This First Amendment, Amendment number 1, will move to strike Section 14, which will remove the requirement that officers' name be withheld from the public in adverse action proceedings. I think that police officers are sworn in and not regular citizens, and we have to be careful that we don't give the public a perception that we're not trying to be transparent about what's happening with our officers. There are a number of issues in the district and across the country in which police officers have done wrong. It's not all of them, but there are some, and the public have a right to know who they are and their badge number. So it is my desire to get support on this, because why are we hiding these officers? If he or she is found not to be not doing any wrongdoing, that should be advertised as well. But it's bad public policy, and we've came a long way about transparency through body-worn camera footage, and it seems like to me we're dialing back. This bill in general is heavy, leaning towards law enforcement, and I think that we have to create a balance by making sure that as we make DC safer, that we are transparent and open about what's happening with our officers.
Councilmember White, you circulated amendments yesterday afternoon that are linked on the agenda. My understanding is you recirculated this amendment at 1:38 this afternoon. How is it different?
Chair, but I don't see any difference in the bill. It was just recirculated. There's no difference in the bill, Chairman.
My staff tells me it's not different, and you are saying you don't think it's different.
Correct.
Okay. All right. Councilmember Pinto.
So I really appreciate what Councilmember White is saying, and I believe that we have to have a transparent and accountable police department. We know that it improves community trust, and we have to have a mechanism to ensure that when officers violate the law, when they abuse their privilege of service, when they violate public trust in some way, there needs to be accountability, period. And we have a lot of accountability measures in the law, whether it's body-worn cameras, whether it's public review of footage when there's serious use of force, and public databases for this, FOIA-able offenses. We treat the police department completely different than we treat any other public agency in the city, appropriately, because police officers carry a gun and have a different set of responsibilities. But with that said, when it comes to their disciplinary matters within the department, I think that we need to consider their employment rights as well, to suggest that they should go through a adverse action hearing. Those hearings are open to the public. If there is a victim involved in that engagement, the victim is notified when and where the hearing is. But the public writ large doesn't need to have access to the officer's name until there is a sustained allegation. And I think that in a balancing of trying to do a lot that we do and we should do for police transparency and accountability, this is one way to also honor employment rights. We would never suggest for teachers, for instance, that anytime there's an allegation for a teacher that it's completely made public with their name and all of their information. This is a way to be balanced about it, and unfortunately I cannot support this amendment today.
Thank you, Mr. Chairman. I wanted to ask a question in terms of Councilmember Pinto. So I believe that the requirement that the officer name and information and there be a public notice, we passed that a couple of years ago. When you go on the MPD site now for adverse action hearings, up until February, they didn't publish the name and the badge number, but they have done so for the February and for the March hearings. Do you know why they changed their action, even though this has technically been law for, I think, at least a year at this point?
So, as far as I've been told, it was an honest mistake. But they have now corrected it and have started to put the names and badge numbers online.
Okay. Thank you.
Councilmember Parker.
I want to thank Councilmember White for moving this amendment. As I've said before, we are in this legislation maintaining accountability for residents, and we ought to do it for MPD as well. I am looking at an example of a calendar of adverse action hearings, and if we were to remove the name and the badge number, for one case, all that would remain is on February 23rd, this case involves a member who was engaged in a domestic incident. That's the extent of the information that is provided. By removing the name and the badge number, we create a significant barrier to informing the public around potential officer misconduct, and it's unnecessary. I would also just stress that there is no reason for this. No one can tell us how this direct action, removing the name and the badge number, improves public safety. What it seems to me, and I acknowledge that the police union may have made this request, and/or police Chief Smith may have made this request. If they can give more persuasive rationale why this is important, and we should undermine transparency and the right of residents to know what is happening for our MPD force, then they should share it. But up until this point, we haven't received that. So for that reason, I do plan to support this amendment. I hope the council supports this because it would be a horrible signal to say we are increasing accountability for residents while decreasing accountability for MPD. Thank you.
Second round, first round, Councilmember Fruin.
Thank you very much. I mean, one of the things, Chairwoman Pinto, that I'm curious about is there was a conversation about there's a lot of different things that might be at these adverse action hearings. And some of them might be more routine employment things where the public's right to know does not seem as compelling, where others could be misconduct, use of force, et cetera. And I think you've said that in those settings, the name is made public in a different avenue. I wonder, I find the argument that there's a class of things that it doesn't make sense to be disclosed, that makes sense to me, but then there are other things where the public has a right to know, and I don't know whether or not we've fully covered those things by the public disclosures in other contexts. I wonder if you could speak to that.
Sure. So the adverse action hearings are when the proposed discipline is termination. So the process to go to the hearing, that is public. The hearing itself is public. As I said, if there was anything that the officer did that involved a victim, the victim is notified when and where the hearing is. But that's what adverse action hearings are. We do have, the Deputy Mayor for Public Safety and Justice will share information publicly when there is serious use of force. All of the information about these cases are FOIable. So it's not that it's impossible to find the name and the badge number. It's that, and kind of going back to Councilor Parker's point too, it's about the totality of what we're dealing with. So when we talk about how we can improve public safety, I understand that this seems a bit attenuated, but we have a police department that is down over 500 officers. And when we talk to officers about recruitment and getting them in the door, we have different requirements and protections in DC than most other places in the country. Many of those are great things because we want an accountable, transparent police department. And in the series of 100 things, if this is one way to say, hey, we're not going to have a public shaming session for an officer before they have been proved to violated their policy and be terminated, we have to get recruitment up, and we have to, this is one way that we can support our police department and make sure that the over 3,300 police officers know that we support their employment rights, just like we do with every other public agency.
Further on the amendment,
Jim.
second round, Councilmember Bonds.
Thank you, Chairman. I just wanted to clarify what I thought Councilmember Pinto just shared with us, that the adverse action is when an officer is reviewed for termination.
There's a question on the floor.
Oh,
Okay.
I'm so sorry,
Yeah,
Councilmember
that's all
Bonds.
right.
Could you please
It was my
repeat it?
fault.
I was just curious. I thought I heard you say that adverse action is when an officer is reviewed for termination.
Yes, that's right.
All right. And so the documents that we're speaking of, the website that we thought we had, includes additional concerns. Am I correct?
The document we're speaking
Well,
of, you mean-
what we're talking about, this particular provision that you're proposing, is it about the adverse action that is up for termination, or is it other kinds of things that an officer may be accused of?
So for this particular amendment, it's adverse action for officers who are up for termination. There are a number of ways that we get information from the police. There's a public database, there's FOIAble offenses, there is a broadcast and sharing of video footage when there's serious use of force. The adverse action hearing process is a kind of similar to an employment dispute to determine whether an officer should be terminated. And that's the offenses that we're dealing with here.
All right, and so to me, that's very serious. And so this report, this manifestation of the names of individuals, our officers that are up for termination, it just seems to me, it does make sense for the public to have access to that. Now, it could be that we could look at it from the perspective of whether or not the action is action that they have taken against other members of the city, meaning us, the citizens, or it could be that it's anything that they have done. And that's what I'm trying to understand. I'm trying to understand what could and should be our preview of having access to this information. I know that probably the police union is hoping that we have no access whatsoever. But I am thinking that it does make sense for us to know when an officer is accused of crime or action against community. So that's what I'm trying to understand.
Further on this amendment, Councilmember Parker, you just look like
Just
you want
30 seconds. I just want to point out,
30-second clock.
I know the analogy has been made comparing officers to teachers, and that we should protect officers' rights. It's worth noting that officers are sworn to their role and have the power to take one's life. And so it is not far-fetched to say we should hold them to a higher standard. I do not think it's persuasive to compare officer adverse action hearings to a teacher's disciplinary action. So I just wanted to point that out. And I agree with Councilmember Bonds that this information, especially if we're considering termination, is exactly the time that we should notify the public of such hearings. Thank you.
Councilmember Trayon White, second round.
Yes, I just want to give some clarity of the seriousness of some of these offenses. And so I gather some of the hearing notices for adverse action from the one I was able to recover was from 2022. And I'll start with some of the high-ranking officials. You have a lieutenant accused of mishandling of seized property. You have a lieutenant of stalking. You have a sergeant, misuse of MPD email. You have a sergeant, DUI, sergeant, AOL, a sergeant assault, you have a detective negligent discharge of a firearm, and this is a 6-page document of 210 offenses. And so these are serious things. So I don't want the public to think that these are light offenses. There was a note that we don't, if someone's fell asleep on duty, that shouldn't be public information. Yes, it is. I've sent videos to the chief and sometimes the commander of people sleeping on duty. That's a serious offense. And out of all these allegations, there were only one on this document from 2022 that was an officer sleep on duty, and that was a detective. Thank you.
Thank you, Councilmember. Councilmember Robert White, first round.
Thank you, Chairman. Most of the arguments have been said at this point, and so I want to clarify something that I think bogged us down for a couple of years and moved us further away from progress. The notion that appropriate accountability for police is not anti-police. And I want to make sure residents are never put into this position where they feel like if they're asking for appropriate accountability for law enforcement officers that do have the power to arrest and take someone's lives, that is somehow anti-police. It is not. Lawyers, if they are disciplined, that is public. If I have a Bega issue, that is public. If I commit a civil penalty, my name will be on the docket in public. If I'm arrested and charged, my name will be public. And I think we're holding police to an appropriate standard for the roles and powers that they hold. And I also just want to be clear that this is not anti-police. This is pro-accountability. And I think police understand that as well.
So I'm going to speak briefly to this, or maybe not briefly. I've been struggling with this issue or amendment. As I've indicated to members, I had discussed with Councilmember Pinto several weeks ago a number of accountability provisions, and there was some back and forth between us, and we, Councilmember Pinto made considerable changes to the bill since the committee print to ensure police accountability provisions. But this was one where she and I agreed that this change would not be made. And so Councilmember Trayon White comes forward with this. And when I looked at it, I looked at the statute. The hearings are still public. There's still a requirement that the subject of the hearing is given in the publication. But, you know, Councilmember Parker makes a good point that when we publish our agenda, we don't publish the bill title without the bill number. Actually, we don't publish the long title without the short title and the bill number. And it's not a secret what these hearings. So all this about is just having a little bit more confusion or a veil over a public hearing, which if you think about it is kind of stupid. Now, my understanding is that the genesis of this comes from the FOP, one of my favorite organizations, because they have stood in the way of accountability. And so I'm just thinking as I'm listening to the debate, there was an officer, this was years ago, it's like number one on my list. He was caught drunk driving. He was on the wrong side of the road in Fairfax County, pulled over, drunk, co-ed in the seat next to him, half naked. The next day, she says he assaulted her. And the arbitration process that the FOP negotiated was such that when the chief fired this police officer, who's good for nothing because he has no credibility, could never show up in a court, the arbitrator ruled that the victim was, the alleged victim was too drunk to be a credible witness, and so the police officer could not be fired. Or, looking at another issue that the FOP has a hard time with, and I might go over my time and I'll try not to, and that was the 90-day statute of limitations that was taken out of this bill early on. I think it was taken out before the committee print, I don't remember, but in any event. So we did a little bit of research on this 90-day statute of limitations. That is, discipline has to be brought within the 90 days, something that the union has insisted on. And we found out that there was a police officer who was arrested. I think he was convicted of burglary, not in the district, in Maryland. And because the discipline wasn't brought within 90 days, he couldn't be fired. A burglar. There was another one, a car thief. He assisted a friend, right? Assisted a friend with stealing a car from a lot. And I think he was Did he plead? He pled guilty. Chief wants to fire him. The disciplinary process that the FOP defends this cop, and so he couldn't be fired. Or DV abusers. You know, it's not uncommon, unfortunately. And the cop beats up his partner, throws her down the steps. That was one of them. Can't be fired. There was one police officer who the FOP defended who had been convicted of dealing in stolen property. This is the process that the FOP wants, and the FOP wants this, not the amendment, but this provision that says, no, we're not going to have the badge number and name, which is inconsequential, as I said, because these hearings are public. So it's really hard for me to stand by where the deal that I had worked out earlier, because this is just too tough to swallow, which is a long way of saying that I'll be supporting the amendment.
All right.
Further on the amendment.
Mr. Chairman? Hi.
Did you want to say something? Councilmember Pinto.
I just wanted to note the list of offenses that Councilmember White read. I mean, there were a number of there that were particularly horrible. There was also misuse of email. Regardless of whether it was a terrible offense or an employment offense, all of that information is public. The hearing is public. This is just about saying, do we want everyone in the public to know Sam Smith did that before Sam Smith has had the chance to defend himself? And that is
Councilmember Pinto, you have the floor.
Thank you. And I just remind people to take into account, again, not the theory, but the reality that we have a police department that is losing officers every month and year. I know we all hear from residents across the city every single day. I know you hear it like I do, that people want more police in their communities. This is not going to solve that. This is not going to solve that problem alone, but it is important to recognize in the totality of the environment that we're creating that it does affect people's desire to come and join our department.
Thank you, Councilmember Pinto. This is not a participatory process. This is, the public is watching the council as we struggle with these issues. If there's nothing further on the amendment, we'll have a roll call vote.
Councilmember Trayon White?
Yes.
Councilmember Trayon White votes yes. Councilmember Allen?
Yes.
Councilmember Allen votes yes. Councilmember Bonds?
Yes.
Councilmember Bonds votes yes. Councilmember Freeman?
No.
Councilmember Freeman votes no. Councilmember Gray?
Yes.
Councilmember Gray votes yes. Councilmember Henderson?
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George?
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie?
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson?
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau?
Yes.
Councilmember Nadeau votes yes. Councilmember Parker?
Yes.
Councilmember Parker votes yes. Councilmember Pinto?
No.
Councilmember Pinto votes no. Councilmember Robert White?
Yes.
Councilmember Robert White votes yes. Mr. Chairman, there are 11 yeses and 2 nos.
The amendment is approved. Councilmember Trayon White.
Yes, thank you. I have my amendment number 2 before us that speaks to face covering and mask. I believe that the portion of the bill that speaks to face coverings and masks was too broad. Contrary to popular belief, I believe that people should not be walking around with ski masks on their face unless they're skiing. And I want to go on record to say I want to digress because I think that Councilmember Janice Lewis George covered a lot of the bases. So as a result, I'm going to withdraw this measure today, and I look forward to working with my colleagues to make sure we are addressing the ski mask provision.
Thank you, Councilmember. So amendment number 2 is withdrawn. Amendment number 3?
Thank you, Chairman. My amendment number 3 speaks to the drug-free zones. I live in a quadrant of the city where drugs is prevalent and have been prevalent for a very long time. and a lot of what happens in these drug-free zones are already illegal. It's illegal to sell drugs. It's illegal to smoke drugs in public. And so this provision of the bill is greatly concerning because I'm concerned that primarily black people will be targeted in these zones. And if we're really serious about creating these drug-free zones and getting to the core issues, then it should not just be MPD that's addressing these drug-free zones. And so this portion of the legislation would include language that ensure that our interventions, outreach, information that includes employment and school and skill training from Department of Employment Services, mental health services, behavior health services, addiction treatment services, and programs in individuals in drug-free zones. It's irresponsible to say we have drug-free zones and don't have DBH working with substance abuse. Police is not the end-all solution to addressing crime, and we don't deal with the underlying issues. They'll just be trying to arrest their way out of the problem, and we know since from history that this is not a solution. So I look forward to getting support of my colleagues on this amendment.
Thank you, Councilmember White. Councilmember Pinto?
Thank you. Thank you, Councilmember White. I think that you raise a really important point that we have to do better as a city to get services to people who need them, particularly who have substance use disorder and use of drugs. This drug-free zone policy is a narrow tool. There are a couple of spots in the city that have become real hotspots of crime, of illegal activity, of weapon sales, and this empowers with a lot of safeguards that I worked with a lot of my colleagues, and especially thank you to Councilmember Henderson for coming up with a lot of really important ideas to make sure that we have notice to the public of where these zones are, that we have notice to DBH and to our healthcare agencies so that they know that this is set up, that we have notice to the council in advance, notice to the public. These are set up for 1,000 square feet. It's a pretty small area for a period of only 120 hours, which is 5 days. So this is not a citywide huge change in policy. This is a narrow tool. And so I think to add all these requirements here is not the right path. And I'll also just suggest procedurally, the amendment seeks to change the definition of drug-free zones and adding these requirements, which will have a cost, which would make it so that we wouldn't be able to implement this in the emergency that we're moving today. And so for all those reasons, I would ask my colleagues not to support this amendment with the recognition that we should all continue to work together to provide much better services to residents in need across the city.
Thank you, Councilmember. Madam Budget Director, is there a fiscal impact on this?
Mr. Chairman, yes, there is. We don't know exactly how much it will be, just given the short amount of time we have to determine these things. But it will have a cost, and the cost will be determined by the entity or entities that will be doing the outreach for within the future drug-free zone, and sort of, you know, the extent of that outreach, whether it's just a poster or if it is social workers, DBH social workers, DOES outreach, things like that.
Thank you. Discussion on the amendment? Councilmember Robert White.
Thank you, Chairman. I want to thank Councilmember Trayon White for offering this amendment. I just want to reassert what Councilmember Trayon White said. It is already illegal, arrestable, and prosecutable to do drugs or sell drugs in the city. And we have areas in the city where open air drug markets are taking place. And we have laws on the books right now that allow our officers and prosecutors to address that. So the idea of creating drug-free zones when the entire city already is a drug-free zone, I believe doesn't solve the issue. And what I worry about this amendment is I worry about a narrative from the mayor or others telling residents in neighborhoods where they're seeing these open air drug markets and are afraid to go to the store, well, we can't do anything because the council voted this down. And that's just not true. We have real issues in our city, public safety issues, drug use issues. We have real issues in our city, and we need to do more than send a message. We need to do more than sort of pass measures that sound good, but don't have the substance to do anything. At the end of the day, if 911 is not answering calls, if we don't have enough people collecting evidence, if prosecution rates are low, none of this changes. But if we start to fix those things, if we fix 911, if we have enough people collecting evidence, if prosecutors enforce what's on the laws now, things turn around tomorrow. And so I want to make sure we stay focused on what's broken, where it's broken, and who has accountability for the parts that are broken. So I look forward to supporting this amendment. Thank you, Chairman.
Thank you, Councilmember. Further on the amendment, Councilmember Lewis George.
Thank you. I agree with Robert, and I obviously agree with Trayon. I do think that this piece of the legislation is probably going to face some constitutional challenges. And I think as a council, we leave it as it is and let the chips fall where they may as it relates to what the result the court is going to come to in relation to this. And so I fall on it for opposite reasons. I agree with Councilmember Robert White and Councilmember Trayon White, but I think we let it stand as it is on its face and face the challenges that I think that are going to naturally come. So thank you.
Thank you, Councilmember. I want to note, because a question was asked to me. So there's a fiscal impact, and the way this is written is it's not distinguishable from the rest of the language regarding the drug-free zone. So the effect of this is that this would postpone putting off the drug-free zones, which of course might be fine for folks who oppose the drug-free zones. But if the council thinks that we need to be, or council members feel we need to be responsive to those who are looking for action, this will undercut the drug-free zone as one of the tools in this bill. In addition, I would note that the language is somewhat vague. It says so it would be a drug-free zone could only be in which the district government has previously targeted for intervention at least twice a week in the 30-day period before the drug-free zone is declared, by providing outreach and information to individuals, what exactly that means, not clear, in that area about employment and skill training services, and it goes on about behavioral health, addiction treatment services, and so forth. So I think I have to agree with Councilmember Pinto that the correct way to provide these services is through the programs that provide these services, and that this amendment as written would at best delay the implementation of any drug-free zones until the fiscal impact was resolved and it was published in the register, funded by the council, published in the register. And even then, it's not clear exactly what it means implementing it.
Chairman.
There's nothing further. Councilmember Trayon White?
Yes, I have to disagree on that. Some of these things already exist in agencies, and DOES has the employment van that goes into communities. DBH has the van that goes into communities. The sad reality that I even heard from the chief of police say that we can't do everything, that we need other agents to get involved. And so when we legislate and get them involved, we're saying not right now, this is not the time to do that. I think that we have to put our legislation where our mouth is. If we say we want drug-free zones, let's be intentional about what we want that drug-free zone to look like, not just arresting people, but ensuring that if someone has an addiction problem, that he or she gets treatment, ensuring that we give an alternative to those persons outside selling drugs, right? And if we want to take something out of their hand, it's imperative that we put something else in their hand. DC has a plethora of resources, but it's hard to reach those who are disengaged into government services. So I do this thing called Resource to the Block. I've been doing it for 7 years. And the amount of impact we have in these areas, we go where people don't go, at the times that people don't go, when people are happy when the government shows up. Far too many times we're showing up after something happens. So we're going to clear these zones. It's imperative to be intentional about getting all the government agencies to provide resources in those zones as well, Chairman. And it's not a budget problem. We have more money right now in DC government than we have in DC history, 20 billion ever. And so it's about a matter of being intentional about how we spend our money if we say we really care about our residents and really want to address public safety. Thank you.
Nothing further on the amendment. We'll have, we seem to be doing roll call votes on all of these. We'll have a roll call vote.
And
Councilmember Pinto.
I'm sorry, I just want to be really clear, because when we talk about the budget, we're talking about passing this on an emergency basis that I hope we will do later today so that we can take effect of these provisions that we all agreed on, most of us agreed on a month ago. And so it will completely kill this intervention for right now. And I actually think moving forward, because I don't think that there would be the support from the executive to do this as intended. And that was a very important part of my process. Not that there's full agreement with the mayor on everything at all, but that we are working with all of our agencies so that every piece of this Secure DC, I can fully have confidence that will be implemented. So we don't just pass legislation and not see it happen. We can really own it and see the improvement. And so I ask my colleagues, despite the very important point that Councilmember White is making about services needing to be improved, to not support this amendment.
Point of clarity.
What's a point of clarity? That means you want to have third round and there's not a third round.
I got a comment though, Chairman. She
yes.
just spoke again. And I should have,
Yes,
it's my bill, so I should be able to speak on it.
She spoke twice. You've spoken twice. Madam Secretary,
Chairman,
would you call the
point
roll?
of clarity, Chairman. I got to give a response to that.
No, you don't. You've already
See what I'm
spoken
saying?
twice. The Councilmember
There's
Pinto
no-
spoke twice. Madam Secretary, please call the roll.
Councilmember
crazy.
Allen?
No.
Councilmember Allen votes no. Councilmember Bonds?
No.
Councilmember Bonds votes no. Councilmember Freeman?
No.
Councilmember Freeman votes no. Councilmember Gray? Councilmember Gray votes yes. Councilmember Henderson?
No.
Councilmember Henderson votes no. Councilmember Lewis George?
No.
Councilmember Lewis George votes no. Councilmember McDuffie?
No.
Councilmember McDuffie votes no. Chairman Mendelson?
No.
Chairman Mendelson votes no. Councilmember Nadeau?
No.
Councilmember Nadeau votes no. Councilmember Parker?
No.
Councilmember Parker votes no. Councilmember Pinto?
No.
Councilmember Pinto votes no. Councilmember Robert White?
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White?
Yes.
Councilmember Trayon White votes yes. Mr. Chairman, there are 3 yeses and 10 nos.
Thank you, Madam Secretary. The amendment fails. The fourth amendment from you, Councilmember White?
Yes, thank you, Chairman. Amendment number 4, Bill B 25-0345, speaks to the need to require the executive office of the mayor to develop and publish a comprehensive safety plan. I don't know about you, but I've been talking about public safety in the district for over 2 decades. And when I first came to the council, the year before was 2016, in which Councilmember McDuffie introduced the NEAR Act. And people thought it was a joke, wasn't funding it. The media ran the narrative that DC is paying criminals not to commit crimes. And you know what happened? When we didn't address the issue, it got worse over time. And so there has always been a narrative that crime was down when I kept going to funerals each and every week, time after time. And so every once in a while, I see or attend a press conference about a new crime initiative, but no real plan. I remember I attended a press conference in 2019 about building blocks, addressing 152 blocks that were high-risk communities, but I haven't heard nothing since. I went to the press conference about the curfew for the youth. I believe the mayor had a press conference, was it yesterday, day before yesterday? And I looking at the report from the National Institute for Criminal Justice Reform, where gave some 16 good recommendations from some studies to CJGC and OGVP. But that was in 2022. It's 2024. I still don't know of those recommendations what is going to get incorporated into a plan. And so it's imperative that if we move forward with our city, we need a real plan. I was here when we were in the pandemic, and I saw when we took public safety serious, the pandemic serious, we had meetings every day, phone conferences, coordinated service with all these government agencies, calls every morning. It was intense. And as a result, it made people feel like we were really doing something about it. We've had a lackluster approach to addressing public safety. And at the time we do, it's highly criminalizing people and highly penalizing. And so if we want to address public safety, we got to have a wraparound approach to address all aspects of public safety. So this provision of the bill requires the mayor to come up with a real comprehensive plan to bring all these different moving pieces together on the one plan that we can follow. Thank you.
Thank you, Councilmember. Is there, Councilmember Pinto?
Thank you, Councilmember White. I will note, we have plans in the city. We have a gun violence strategic plan. We have public safety plans that need to be implemented. We have major challenges with implementing the advice and plans that have been promulgated that experts both in DC and across the country have worked on. With that said, I appreciate what my colleague is trying to do and really focus the city in ensuring that we have a comprehensive public safety plan moving forward. And so I will be accepting this amendment as friendly.
It's only accepted if there's no objection. Is there any objection to the amendment? Hearing none, it's accepted. The next amendment.
Mr. Chairman? And maybe this is late in the process. Can I offer an amendment to the amendment?
It's already been accepted.
Okay. Well, if I could just, for the record, yes, to add a time certain here.